Welcome back to Sunrise 542 your time. In the news each morning we tend to talk about tragic and often unexpected events that impact people's lives, sometimes permanently. And as a mom, I know how important it is to make sure my family's taken care of if there is a crisis.
Yeah, unfortunately things happen. And Julie, as a new dad, I learned pretty fast how important it is to draft certain legal documents just to make sure that your wishes are carried out in case something happens to you. It's so important to have those binding legal documents in place in case you become disabled due to an illness or an accident. Look, these things aren't easy to talk about, but attorneys say every adult needs them. There are 5 key documents really involved in estate planning. So let's start with the top 3 with the help of Indianapolis attorney Sean Scott. So the first is a general durable power of attorney. Now, this document outlines who you want to make decisions for you if you can't make them for yourself. We're talking about your money, your property, and your bank accounts. Otherwise, your family may have to petition the government to become your legal guardian. That's time-consuming and costly. However, if you have it, they can do things for you.
Go ahead and get your mortgage paid, your rent paid, your bills paid. So you've really allowed someone to step into your place, handle your business and financial affairs for you when you can't do it for yourself.
Number 2 is healthcare power of attorney. So in case you can't make your own healthcare decisions, you need to have someone you trust, like family members or friends, in charge. This would typically be in an emergency where you can't tell your doctor what you want. Instead, they'll simply follow Indiana law.
The state of Indiana is always going to have a fallback. They've made a plan for you if you don't have one for yourself, but you don't have a say over who that person is.
That's right. And lastly is what they call a living will. These are your wishes for end-of-life care. So if you have, say, an incurable injury, a disease or illness, this document essentially details your wishes as far as life support.
And you want to make sure that your family members and your physicians know when you can't have that voice how you want your end-of-life care to be.
And now a living will, technically different than a will. We're going to break down the differences and why you need one coming up at 6:45. And also, if you're a parent, we're going to talk about setting up a trust for your children. And I know when the word trust is thrown around, a lot of people think that means you have to be really wealthy, a multimillionaire to need a trust. It's not true at all. And a quick side note, all those documents I just mentioned aren't legally binding if you just write them down, right? If you write it down on a piece of paper and say, this is what I want. Well, if it's not notarized or drafted by an attorney, it doesn't hold up in a court of law here in Indiana. So it's important to do this and sit down, and I'll tell you how much it will cost you in time and money coming up at 6:15.
And it's so important to do this because if you some way leave this world and you leave your loved ones behind, there's so much that they have to deal with. So it's nice to help them out and take that step.
You put a lot of pressure on them if you don't have this done. So it's kind of easing their burdens as well.
All right, good. Nice look at that. We appreciate it.